ये चल रहा है ऑन चल रहा है जज ब्रावर भी आ चुके हैं हेलो जज ब्रावर कैन यू हियर मी okay so let me see if we can hear you in the hall uh-huh. Not in the hall yet so people are just pouring in so I thought we will test the screen and speaker yep just checking if what is fine sorry connection is fine yes despite the disruptions by the firewall I think we are okay. So I hope I haven't disrupted your morning plans. उनकी नहीं आ रही ना uh, Judge Prabha, could you disconnect and join again? We are having some sound issues on this side. Can you hear me? Judge Prabha, can you hear me? I can hear you just trying to get you on the loudspeakers in the hall. So they're trying to change the audio settings. हाँ हाँ वो तो कर रहे हैं उनको तो आ रही है हमें जो है हॉल में नहीं जा रही Judge Prabha, could you say something so that I can test the speaker? I can hear you just on the computer, my computer speaker. Resolve करें जल्दी इसको. इसको बुलाएं. वकील साहब किधर हैं? जरा बुलाते हैं. जी. Judge Pravar, I'll disconnect the call for a second and sign in again. Disconnect करें. The ये कोई और नहीं जिनको पता हो क्या मेरा ईमेल है आपके पास? हाँ, अगर जो है ना आप जब नंबर रखें, लेट्स हैव अ कन्वर्सेशन, इतना पूरा तो मैं जूम कॉल की आवाज़ नहीं आ, so I need to sort that out. So ठीक है, एक चीज़, ठीक है, आवाज़ जूम को देखो आज टाइम थोड़ा सा गया,
हेलो माइक चेक वन टू। डन हो गया बॉस। अब मैं अपने दो माइक ऊपर भिजवाऊँ या आप वाले दो भिजवाऊँ? जैसे मुझे दे दे दीजिए अपने। लेकिन एक चीज़ ध्यान में रखना है, इसको ना ऑफ रखना है, जब ज़रूरत पड़ेगी तब ये ऑफ नहीं, इनका एक अक्षर नहीं 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 नहीं, मैं आपको बता देता हूँ, ऊपर का माहौल बता देता हूँ बॉस। जब ऊपर वाली बारी आएगी ना, ये ऑन ही रहता है। स्टेज पे माइक रखी यही जा रहा हूँ अभी जा रहा हूँ। कितने दिन है? 2 दिन। आपकी जो 3 है वो कर रखा है नीचे के लिए, ये तो आप वाले हैं ना। नहीं ये मत रखें, ये भी है सारे वजह कोई मेरी बात अच्छा इन मत रखें। होता ये है कि एक बंदे के पास है, दूसरे बंदे के पास है, तीसरे बंदे के पास नहीं, ऑन रह जाते हैं, मिक्स होता है काम और ये ज़्यादा। हाँ, 2 दे देते हैं असल में ना, फिर जब बंद ही तीन स्विच करेंगे ना तो 3 बंदों के लिए 2 पड़े रहे ना, तीनों घंटे तो सर एक आप बात कर रहे हैं, एक फ्री पड़ा हुआ है जिसको चाहिए वो मेरा बात कर। तो 14 डॉलर है आप वो इतना एक टाइम पे 3 बंदे हैं तो आप कह रहे 2 ही काफी। हाँ बहुत बहुत आ जाए बहुत बहुत। तो इसमें देख लेना बाद में कुछ अटैच तो नहीं हो रहा।
आपको नहीं कहती मैं इनको
हेलो, माइक चेक। बिलाल साहब आवाज़ आ रही है? इसको
हेलो माइक चेक 1 2 3। हेलो हेलो माइक चेक 1 2 3। हेलो माइक चेक 1 2 3। ओके दिस वन चेक 1 2 3। हेलो 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 माइक चेक 1 2 3 है। हाँ हाँ बिल्कुल वो सारी चीज़ें मैं देख ली।
नहीं चला तो फिर इसी से भागना पड़ेगा, यही मुझे ताकि मैं एक्टिव हो पाऊँ। अभी एक Hello. Hello, mic check. Hello, mic check. Hello. Hello, mic check.
You're checking if you can hear me, Judge Brower?
Okay, yes, we can hear you. Thank you.
Okay.
Good evening, everyone. Mic check. Are you able to hear me? Ellen Bass from San Francisco. Are you able to hear me, Anran?
I'm hearing somebody.
And Judge
I can
Brower
hear
is
you.
hearing me? Okay. Just confirming that they're able to hear me in the room.
I'm not sure the room.
Thank you for enabling the visual on the room as well.
Can you hear me? Yes. Okay.
I can hear you.
Okay.
I can
Ladies
hear
and
you as
gentlemen,
well. Can you hear me? Can you hear me?
an echo जरा देखेंगे. Ladies and gentlemen and our esteemed guests, welcome. I am Dr. Nudhat Piracha, CEO of the International Center for Appropriate Dispute Resolution and Prevention and partner at Samdani and Qureshi. Today we find ourselves at a pivotal moment. We are at a pivotal moment in history as we gather to mark the conclusion of the first national rounds of the 32nd Moot competition. The Moot, let it be said, stands at the foremost of its kind, a beacon in the world of moot court competitions, setting the golden standard for legal education and advocacy. Let us begin by offering our heartiest congratulations to the winning teams. Indeed, a round of applause is due to all the contestants and universities that took part in this rigorous competition. They have toiled tirelessly, and in doing so have inscribed their efforts into the annals of history by participating in the very first national rounds held in Pakistan. A big round of applause for all the teams, please. I must extend my sincere thank you to Justice Miangul Hassan Aurangzeb, the delegates of Commercial Law Development Program from the US Department of Commerce, who have joined us from afar, the esteemed guests who have joined us online, and all the dignitaries and participants, both from Pakistan and beyond, who honor us with their presence today. A special note of gratitude to Ikra University for making this auditorium available to us. We would be remiss not to recognize ICADRIP and the dedicated team of Samdani Qureshi Aklal, who have made this event possible. Turning to arbitrations in Pakistan, the pace of arbitration has not been swift. International arbitrations in particular have languished, hampered by the inadequate capacity of the legal system, the practitioners, and the litigants. In the past 2 years alone, in 1940 arbitration in cases of significant magnitude have dragged on for unconscionable 25 to 40 years from start to finish. Yet we live in an era ripe with promise of change. There is serious talk of overhauling our outdated arbitration laws, and the judiciary, judges like Justice Aurangzeb, they are playing their part by giving pro-arbitration judgments and actively participating in redefining Pakistan's ADR landscape. Our university and law students are the bedrock of this evolving system. To neglect their development would be a grave oversight. ADR must become a mandatory part of the curriculum, and universities should establish clinics to cultivate arbitrators, mediators, and ADR advocates, thereby promoting the practice of ADR and alleviating the burden of our courts. ICADRIP is at the forefront of this capacity building effort. Certified as a mediation training provider by the International Mediation Institute, IMI, and collaborating with leading American universities and institutions to bring advanced ADR trainings to Pakistan. Moreover, ICADRIP stands as a government-designated center providing essential ADR services. In the near future, ICADRIP will publish a discussion paper on proposed arbitration bill of 2024, which builds upon the 2016 bill that was regrettably never enacted. The 2016 bill itself was modeled after the Indian Arbitration Act of 1996. This paper for discussion and guidance of the stakeholders will be one of the many contributions to the future of Pakistan in ADR. ICADRIP also provides administrative services for arbitrators and boasts a panel of over 100 national and international arbitrators and mediators. I urge each of us to contribute to this cause to the fullest extent of our abilities, in whatever capacity we may serve. Our collective efforts will define the future of arbitration and ADR in Pakistan, as it is the people who will define the success of the new ADR era. Without further ado, I will invite Justice Miangul Hassan Aurangzeb to speak about the future of arbitration in Pakistan. He requires no introduction. He is one of the champion judges redefining ADR ecosystem in Pakistan. So he's a judge, for those who do not know, of the Islamabad High Court, and he is a respected jurist with extensive experience in constitutional, corporate, and commercial law, having pursued legal education in the UK and being called to the bar of England and Wales. He builds a distinguished career representing clients before Pakistan High Court, Supreme Court, and international tribunals. In 2015, he was appointed as an additional judge of the Islamabad High Court and became a permanent judge in 2016, where he continues to deliver impactful judgments across various areas of law, in particular arbitration. So please welcome Justice Mia Hassan Aurangzeb to the stage.
Thank you very much, Nudrat, for that introduction, a lot of which I don't deserve. It's a matter of singular privilege for me to be here at Iqra University on the invitation of Mr. Farooq Kareem Qureshi. He has been my inspiration now for almost 30 years, because when I first started reading law, it was in my A-levels, and he was my teacher. He taught me law, and my interest in law developed because of him, and I decided to make it into my career. So here we are. I'm also privileged to see, as a part of this function, Judge Charles Brewer. I had the opportunity of being one of the team members in the legal team representing the government of Pakistan in a treaty arbitration arising under the clause contained in the Pakistan-Mauritius BIT, popularly known as the pro-gas arbitration, which resulted in a claim of $573 million being dismissed by the arbitral tribunal, and one of the members was Honorable Judge Charles Brewer. The law with respect to the alternative dispute resolution, I'll confine myself to the Islamabad Capital Territory, is contained in two statutes. One is the Arbitration Act of 1940, and the other is what is popularly known as the Foreign Arbitration Act of 2011. The 1940 Act is a codified law, because earlier the law of arbitration was contained in the Arbitration Act of 1898, as well as the Code of Civil Procedure. What the 1940 Act did is to repeal the chapter on arbitration in the Code of Civil Procedure, as well as the earlier Arbitration Act, and this codified law was made. The manner in which the 1940 Act has been interpreted has created so many pitfalls in the smooth and quick process of arbitration. Arbitration is supposed to be an expense-saving device, a time-saving device. But the manner in which this law has been applied, as stated by a judge of the Supreme Court in the case of Guru Nanak Foundation, is that it has made legal philosophers weep and the lawyers laugh. This statement of the Honorable Supreme Court in 1981 of India resulted in the Arbitration and Conciliation Act of 1996 in India. In Pakistan, under the umbrella and under the basic framework of the UNCITRAL model, there is a bill that has been tabled in the National Assembly, which, if passed, would be a welcome development in the law of arbitration, because there are, if I'm not mistaken, 92 countries in the world that have adopted this very model. It would make the interpretation of that law by the courts in Pakistan very simple, for the reason that different courts around the world have interpreted these very provisions. Pakistan has the same provisions with some modifications. Those modifications were necessary given the difficulties that the UNCITRAL model faced in India over the past 25 years or so. So the Pakistani law is an improvement on that. But today, as we speak, the 1940 Act is still in existence. Whether that new Arbitration Act is enacted or not remains to be seen. An interesting thing happened in my court last month, sir. There was a dispute regarding a question of law that had never been interpreted in Pakistan before. The question was whether the replacement of an umpire, which is appointed by the two arbitrators in a three-member tribunal, is to be made by the court or the parties. One of the parties had objected to the umpire sitting in an adjudicating capacity after there had been a dispute between two arbitrators. And he, although recused himself in the recusal order, observed that the parties can approach the court for the appointment of the umpire. That order was challenged before me. Now, the first thing that came to my mind is that why do I need to do all this when the act is not going to have much of a life, but it is our duty to interpret it. And there was only one judgment of 1973 in India by the Indian Supreme Court, which took the view that once the arbitrators exercise their power of appointing an umpire, they exhaust that power. So the replacement of an umpire cannot be appointed by the two arbitrators but by the court. And this is indeed what the court had done. It had appointed the replacement umpire. I set aside that judgment of the civil court by holding that the true interpretation of Section 8 of the Arbitration Act is that where the parties agree for the arbitrators to appoint an umpire, and where the arbitrators do not appoint a replacement in the event the umpire refuses to act, it is only then that you can go to the court for the appointment of the umpire. In this case, the arbitrators were never given an opportunity to appoint a replacement. Now, the reason why we did that is because an arbitration contract is, after all, a contract. It is enforced like any other contract. And the party autonomy gives parties the power to make the arbitration agreement in the manner of their choosing. The arbitration agreement can provide for the disputes raised by one party to be referred to arbitration but not the other. It can provide for preconditions for the initiation of the arbitration proceedings, like nowadays it is preferred that the parties go for mediation first, and where mediation fails, that you can go into arbitration. So here in my case, the parties had agreed that it is the arbitrators that are going to appoint the replacement. So it is the sanctity of contract that had to be respected by the courts. So a detailed judgment was given, differing with the law laid down by the Indian Supreme Court. This was done just the other day. I don't know how long that law will remain valid for, but nonetheless, it was our duty to do that. Another important aspect of the ADR, which is now gathering momentum, thankfully, in Pakistan, is mediation. Mediation is the preferred form of the settlement of disputes. It is informal. The mediator does not decide the case. He does not sit in an adjudicating capacity. He facilitates the parties to come to an amicable settlement. He has to develop a rapport and an understanding between the parties. He's not supposed to give them legal advice. He has to explain to the parties that whatever they say in the mediation proceedings would be confidential and would be without prejudice, so they can speak their heart out to him in the mediation proceedings, because whatever they say, they are not going to be quoted on that tomorrow if the mediation fails and the matter lands up in the court. In the Islamabad Capital Territory, we have an adequate legislative framework for the mediation to be a success story. We have the Alternative Dispute Resolution Act of 2017, which provides for mediators to be appointed and notified by the federal government. The term for mediators used in this act is neutrals. They have to be lawyers of at least 7 years of standing, but they can also be jurists, they can be technocrats, they can be ulama, and people of standing. Regardless of that, the parties have been given the autonomy to choose their own mediator, regardless of whether he has the 7-year experience as a lawyer or not. Once the mediation proceedings are successful, the Act provides that it is the mediator that is to draw up the settlement agreement between the parties. He has to sign it, the parties have to sign it. And once that happens, it is taken to the court in order for life to be infused into it. What I mean by that is that a status of a decree is given. It is then like any other judgment and is enforceable by a court of law like any other judgment. But if there's an earnest effort made by the parties to mediate and it is unsuccessful, you've got nothing to lose. You can still go to the court. But we in the Islamabad High Court are of the view that in order to make mediation a success story, there has to be a very robust costs regime. The mentality of the district judiciary as well as the High Court, I must admit, has to change. It has to be kept in step with the changing social and economic conditions. The Islamabad High Court has a pendency of more than 16,000 cases. It is not humanly possible for 8 judges to clear that. The pendency of cases before the district judiciary is 53,000, with cause lists going more than 100 for each and every court. It is not humanly possible for this litigation to be cleared. But mediation is the manner in which the parties can, while the case is pending, resort through a process in order to explore the avenue of an out-of-court settlement. And if it doesn't settle, you've got nothing to lose. The courts are there and duty-bound to decide the cases. But we have also made the mediation rules which provide that where a party unreasonably withholds its consent to mediate, that refusal will play a role in the court ultimately in making an award for costs. And this is exactly what we have at least done in the Islamabad High Court, where mediation is suggested by a court, it is put in the order, and a party says, no, I want a protracted litigation to take place. And ultimately, when they lose, heavy penalties in the form of costs are imposed. And these costs are not lip service. These costs are meant to pinch. Recently, the Legal Aid Society took a team of judges to Gilgit-Baltistan to study their model of mediation. Sir, I tell you what a success story it is. In the district of Hunza, there is the courts complex. But you will be surprised to hear that there is only one court of district and sessions judge, and 1 court of a civil judge. That is it. Why? Why not 60, 70 courts like Islamabad? The reason for that, sir, is that in the district court, there is a total pendency of 82 cases as of yesterday. 82 only. And in the civil court, there is a total pendency of 160. Just 82 and 160. When we went to the court, it was so clean and the floor was so shiny that I didn't want to step on it. It is like a dream come true for an adjudicator in Islamabad. And the reason for that is that every year there are 8,000 disputes which are settled through mediation in the district of Hunza only. They have local mediation centers where parties have faith in the mediator and he is able enough to resolve their disputes. I had a word with the senior puisne judge of the Supreme Court and told him that this is a model that we must emulate in the rest of Pakistan. The panelists are waiting, and as I said, it was a privilege for me to be here at this august educational institution, and I won't keep you anymore. Thank you very much.
Thank you very much. Now, turning to our guest speakers who have patiently been waiting. The first speaker is Judge Charles Brower. He's the patron-in-chief of the International Center of Appropriate Dispute Resolution and Prevention. With an illustrious career spanning over 55 years, Judge Brower has been at the forefront of public international law and international dispute resolution. He has handled cases across all 6 continents, engaging with a variety of arbitration rules. His tenure as a judge at the Iran-US Claims Tribunal in The Hague started in 1983, with a brief interruption in 1987 when he served as Deputy Special Counselor to President Reagan. Notably, since 2014, Judge Brower also contributed his expertise as a judge ad hoc at the International Court of Justice. So, Judge Brower, the floor is all yours.
Thank you, Dr. Pracha. Good evening. Excuse me. Good evening to all you who are present this evening, beginning with the distinguished guests, especially our honored chief guest, Islamabad High Court Justice Mian Hassan Aurangzeb. And thank you, Justice, for remembering that case, and very nice to be with you again. Our other speakers also this evening should be honored, Mr. Anrang Zhang and Ms. Ellen Bass, as well as Mr. Eric Ives, who will moderate the panel that immediately precedes this evening's dinner. Ladies and gentlemen, and of course, all you students who have been competing in the first ever Pakistan national rounds in preparation for the Willem Cornelis Vis International Commercial Arbitration Moot competition in Vienna. I also want to credit Igra University for its generosity in accommodating all of this in its auditorium this evening. As Dr. Pracha said, I am Judge Charles Nelson Brower and appear in my capacity as patron-in-chief of the International Center for Appropriate Dispute Resolution and Prevention, known for short as ICA DRP. which sponsors today's events. Now, although Dr. Paracha said some things about me, perhaps I should explain how I came to this high honor of being the patron-in-chief of this organization. But also, I want to address the role of the ICA-DRP in this country and abroad. Apart from practicing with the global law firm of White and Case LLP for several decades, actually 3, I think, altogether, while also sometimes in public service, I was first practicing in New York City, later in Washington, D.C., and since 2001, I have been practicing as an arbitrator member of 20 Essex chambers in London. I have, during that time, I have held the following positions in public service. And an awful lot of it has to do with ADR, particularly arbitration, although I actually was appointed in a conciliation at one point. From 1969 to 1973, I was serving in the Office of the Legal Advisor of the United States Department of State, rising from assistant legal advisor to deputy legal advisor to many months as the acting legal advisor of the department. Next, since 1983, and still today, I have served as a judge of the around the United States Claims Tribunal in The Hague, in the Netherlands, where I had resided for 21 and a half years as a titular member. And I remain today a member of the diplomatic corps as a result in the Netherlands. Now, as Dr. Pratt mentioned, for a significant period in 1987, I was granted leave from the tribunal by my colleagues in order to serve in the White House as Deputy Special Counselor to the President of the United States. And as Dr. Paracha mentioned, it happened to be President Reagan. I did that with the rank equivalent to a Deputy Secretary of a government department. Later on, I served for several years as a judge ad hoc of the Inter-American Court of Human Rights in San Jose, Costa Rica. And of course, as Dr. Paracha mentioned, from 2014 until 2022, I sat in 3 contentious cases as judge ad hoc of the International Court of Justice, known commonly as the World Court, also in The Hague. The first of those cases, I was appointed by Colombia. Actually, in the Inter-American Court, I had been appointed by another South American company, Bolivia, and then twice by the United States in cases brought against that country by Iran. Now, this was all accidental in a sense, but these 3 appointments have resulted in my being the most appointed American as judge ad hoc at the International Court of Justice of the only 5 Americans who have ever been appointed to that position. Oh, in short, I have been involved in ADR, in fact, ever since I was in the State Department negotiating with the Soviet Union, with the result that a trade agreement that I was a chief negotiator in resulted in them agreeing to arbitrate disputes with, between state-sponsored trade organizations in the Soviet Union and American companies before any system that the parties would agree to. Now, I should add, along the way of all of this, I actually have been to Karachi and also to Islamabad. So I'm not exactly a stranger to Pakistan. Now let me turn to the important subject this evening, and that's the importance of the sponsorship of this event and the national purpose of it. The ICADRP is a Pakistan government designated center recognized by the Ministry of Law and Justice and the Islamabad High Court, to which judges of Pakistani courts may refer cases for mediation. I won't be covering ground already very well covered by my predecessor on the stage this evening. Thank heavens, gave a very strong statement in favor of this, concentrating on mediation, which I have no disagreement with. I just do not have the experience myself. It's mostly in arbitration. But they can do it for arbitration, mediation, other forms of alternative dispute resolution. Now, in passing, I may add one comment. There is something called the Singapore Convention on mediation, which for states which adopt it, obligate them to treat the result of a mediation the same as an arbitration under what is known as the New York Convention. Some of you will be familiar with that. In my capacity as the center's patron in chief, I have long since learned through various meetings in which I've been involved, which mostly were attended by Pakistani judges, that the Pakistani judiciary very strongly supports their government-approved ability to refer cases before them elsewhere for forms of alternative dispute resolution. Now, that includes arbitration, and they are able to do this due to the fact, and the judges want to be able to do this, due to the fact that the courts of this country, generally speaking, are overwhelmed. I'm underscoring what the justice said earlier. They are overwhelmed so much that cases that remain in courts too often face significant, and I believe he said unacceptable, I agree with that, delays. Now, as a result of that, the ICADRP already is receiving referrals. It's new, relatively new, but it is leading very well in receiving referrals from the High Court, as well as privately generated referrals by parties who don't want to go to court in the first place and would rather mediate, arbitrate, or follow some other form of ADR. Now, the fact that the ICADRP is sponsoring this evening and the day, that it is able to organize what has happened. Look, the students present have been arguing today a commercial arbitration case before mock tribunals. Clearly, alternative dispute resolution must become the future of Pakistan. The ICADRP is the foremost leader paving the way to that future, and its strength in doing so is being enhanced by the various public-private partnerships it has formed, largely due to the efforts of Dr. Paracha. Now, those partnerships strengthen the capacity of the center, hence its delivery of services. The partnerships are with the International Law Institute in Washington, D.C., affiliated with Georgetown University's Law Center. Also, another is the Weinstein International Foundation, which actually was founded by some of the founders or organizers of something called JAMS. That's not something to put on your bread at breakfast. It is the Judicial Arbitration and Mediation Services. Another player in this with the center is George Washington University's Law School, which, as I think is well known, Dr. Paracha is a graduate with a doctoral degree. Also, another one is the Washington College of Law of the American University. And finally, Pepperdine University's Law School out in California. The country is spread from west to east with cooperative institutions with the center. In addition, the center, ICADRP, has been accredited, as I think Dr. Paracha mentioned, and it's due to her efforts, by the International Mediation Institute, an international organization, as a certified mediation training provider, thus positioning it to provide high-quality ADR training in Pakistan. Also, it makes recommendations on how universities can establish courses and clinics that promote ADR and support the integration of ADR, as Dr. Paracha wisely mentioned, as a mandatory, or in proper English, mandatory course in university curricula. This is exemplified by Punjab University, where it now applies. These courses, these experiences that people have been having today are in order to prepare students to practice commercial arbitration as a form, one I know well, and other forms of ADR as well, including mediation and other forms, thereby better enabling the courts to refer cases to ADR, because there will be growing number of lawyers trained in the field. Therefore, I think we all should celebrate this day, the first step in Pakistan to bring together law students, faculty, administrators from 20 universities in Pakistan, including Hyderabad, Islamabad, Jamshedpur, Karachi, Lahore, Multan, and Peshawar and Punjab, as I've mentioned, and to which I add Rawalpindi. This is all for the purpose of sharpening students' abilities to argue commercial arbitration cases, in particular, as a start, with a view for the first time to compete internationally and thereby to provide the so urgently required increase in the country's supply of ADR practitioners. I say hail to all present for their determined and active support of this cause, especially all of the foresighted students competing today and thereby becoming Pakistan's ADR future. I thank you for your attention.
Thank you very much, Judge Brava. Our next speaker is Ellen Bass. She is the Executive Director of the Weinstein International Foundation. Ellen Bass brings a wealth of experience to this event as an accomplished attorney, trained mediator, and the Executive Director of Weinstein International Foundation. In her current role, she manages the foundation's daily operations and works closely with the board of directors and a global network of senior fellows to implement strategic initiatives. Her leadership has been instrumental in the development and growth of the Weinstein JAMS International Fellowship Program, where she has fostered a dynamic and expanding international network of ADR-trained dispute resolution professionals since 2009, to which I too belong. So Ellen Bass, over to you.
Thank you so much, Dr. Paracha, for those kind words. And maybe you've already provided a sufficient amount of information, since I think that, we have such distinguished speakers here. I want to thank Judge Charles Brower in particular for mentioning the Weinstein International Foundation as one of the key public-private partnerships that works to support the International Center for Appropriate Dispute Resolution and Prevention, or ICA-DRP, as Dr. Paracha has called it. And I also sincerely want to thank the Honorable Justice of the Islamabad High Court for his illuminating and instructive discussion today about the developments of arbitration and also mediation. And also, of course, thank you again, Judge Brower, as well, for providing us with your insight in terms of the developments for arbitration and also mediation and your experience in Pakistan, which I'm sorry to say that I have not yet had the privilege to visit, but I hope someday I will. So as you've heard, my name is Ellen Bass. I am the Executive Director of the Weinstein International Foundation, and I am also the Director of the Weinstein JAMS International Fellowship Program. So Dr. Paracha asked me to speak a little bit about those two organizations, and before I do so, I want to again congratulate all of the students, as Judge Brower has, for their extraordinary efforts at being part of this historic next generation of leading practitioners by participating in the Pakistan National Rounds for this 32nd William Viss Moot Court in International Commercial Arbitration, which we all know is now one of the largest moots. As Dr. Paracha mentioned, an extraordinary opportunity to learn and advance your arbitration skills, and then also an extraordinary opportunity to interact with other like-minded young up-and-coming practitioners around the world. So I congratulate you all for all of your efforts, and I'm so privileged really to be able to speak to you about your opportunities in the field and becoming the next leading generation, as I mentioned. So the Weinstein International Foundation is a nonprofit located in San Francisco. And as Judge Brower said, it was founded in 2018 by some of the leading ADR practitioners, specifically some of the leading mediators in the United States and internationally, in particular Judge Daniel Weinstein, who you may have heard of, who is one of the leading mediators of complex civil disputes and has been invaluable in developing dispute resolution around the world. It's truly his generosity and his vision that underlie both the Weinstein International Foundation as well as the Weinstein Jams International Fellowship Program. So the Weinstein International Foundation works, as Dr. Paracha said, through a leading global network of what we now call senior fellows. The senior fellows are primarily judges and lawyers from all around the world. There are more than 150 of these senior fellows today from more than 75 countries. And they have been involved over a decade in the development of ADR in different capacities, whether working in connection with their courts, if they happen to be judicial officers, or whether starting centers, as we see Dr. Paracha has done with ICA-DRP, as well as working on legislation, working on UNCITRAL, the development of the Singapore Convention, working to develop community mediation truly around the world. The breadth of their involvement in various international initiatives to advance dispute resolution is extraordinary and continues to grow. Why does it continue to grow? Because the senior fellows are selected or invited to participate in the Weinstein International Foundation after they have successfully concluded their participation in the Weinstein Jams International Fellowship Program. The Weinstein International Fellowship Program has existed since 2008, and it is a program provided by JAMS, one of the sponsors of the VIS for many, many years that you might have heard of that Judge Brower mentioned. And it offers opportunities for students, such as yourself, as well as other practitioners, to come to the United States and to study dispute resolution practices and procedures in a project of your own design, and to spend time in the United States, and then to return to your home countries to advance whatever the objectives were of the proposal that was submitted as part of that fellowship application process. So, Dr. Paracha is an extremely successful graduate of the Weinstein Jams Fellowship Program, and thus also an extremely active and inspiring member of our global network of senior fellows. And it's on her behalf that I was invited here to speak and to be able to provide that information to you, to the students. For those of you who might be interested in learning more about these opportunities, I am sure that Dr. Paracha will be able to provide you with more information. We are constantly developing projects and initiatives. We also will be running a mediation advocacy brief writing competition in Pakistan that Dr. Nadrat, I believe, will be leading. That will be taking place this fall. And I just want to, again, thank you all for the opportunity to be here with you, to be able to provide these very brief remarks. I know that we have Dr. Anran Zhang, who's also going to be speaking. And I also believe that we, the guest speakers who are here online, may stand between you, the guests who are there in the audience, and your dinner, and then perhaps also a panel. So I do want to keep my remarks brief. As a wise woman, we don't want to stand between you and the next key moment, which will be your dinner. But I wanted to thank you and congratulate you, and just, I'm so pleased to be here. So good luck for your future efforts. And also, we look to you all, as Judge Brower said, for becoming this next generation for Pakistan of leading ADR ambassadors, whether it be in the field of arbitration or mediation or other processes or practices that you may be developing. So thank you, everyone.
Thank you very much. Okay, the last speaker today is Dr. Anran Zhang. One could not be talking about international commercial arbitrations without mentioning ICC. So he is the Deputy Director of the International Chamber of Commerce, ICC, Arbitration and ADR for North Asia. Dr. Zhang's effort has been pivotal in connecting ICC's arbitration services with regional businesses, advising on arbitration protocols, and leading initiatives to promote ICC's global dispute resolution mechanism in North Asia. His expertise in international arbitration and his leadership in fostering the integration of ADR practices in complex legal environments make him a key figure in this field. So let us all welcome Dr. Andren.
Thank you, Nudra. I try to be also very brief. So dear Judge Brower and Justice Miango, and also Ms. Bass, distinguished speakers, and also dear Nudra, organizers, and dear participants of the 22nd with Moot Pakistan National Rounds. So this is Anran. So I'm the Deputy Director of ICC Arbitration and ADR for North Asia, and warm greetings from Shanghai, China. So it is really my great privilege to be with all the distinguished speakers. And also I'm very happy to virtually come back to Islamabad after my amazing days in this May. So I feel really great. So first, I would like to thank Nudra for her kind invitation, and also congratulations to her on her latest appointment as the delegate of the ICC Commission on Arbitration and ADR. So for all the participants, I try to be nice ICC tonight, but just to share some of the keywords with you in this journey for the Moot competition. So I'm sure you will enjoy the Gala tonight, which I'm sure is also a good start for the upcoming pre-Moot and also West East Moot competition, as well as the West Moot in Vienna next year. So I will start with the Pakistan, the P. So I would say the be patient and careful when you prepare your strategy and your written memo, as well as when you prepare with your oral arguments. And the second, I would say, be more attention. So read your moot problem several times and try to remember the details. For example, to check the references that you make and the cases that you refer to. And third, be knowledgeable. So I think you already have this experience that to make the preparation, you need to understand the basic knowledge of the arbitration rules that applied in that year, and also the most importantly, the CISG. So be knowledgeable about the key materials and have a systematic understanding of all the legal and also the factual elements of this moot problem. And fourth, be intelligent. I'm not saying that you write your memo with the help of the OpenAI, and I assume I have already read that the organizers of the moot competitions has issued the guidelines of using the OpenAI. So however, I think I will encourage you to try all the helpful database. And now I think many of the database are empowered by technology, and some also offered free trial for the universities, which I think is really helpful for your preparations. So for example, ICC dispute resolution library may be something you can consider when you search for your materials. So all the ICC rules and also the notes, as well as the ICC Commission report are available free online. And also you can check the latest issue of the ICC bulletin, but only the latest issue is also available at the ICC dispute resolution library. So this is some kind of tips. And fifth, I would say be skillful and practice your arguments, work with your arguments with your teammates and also with other teams in the pre-moot, in your upcoming pre-moot if you have, and you will learn the new ideas from the others and also be skillful in your arguments. Sixth, I would say the teamwork. So I think this is the reason why you may separate your works with your mates in the procedure matter and also the substantive matters. Or some of them may represent the claimant and some of them may represent the respondent. But teamwork is always the key for your moot competition. And seven, I would say, is absorb. So you need to absorb all the skills and knowledge you gain and make them be part of yours, and you will grow. And lastly, I would say is the network. So get connected with your schoolmates, your peers, and also your competitors during the moot competitions. Because later I'm sure that you will become the friends and you will work together and grow together. So I would say this is also one of the most amazing parts of the Moot competitions. So for now, I may also encourage you to join the ICC YAF, so the ICC Young Arbitration and ADR Forum, which I have been shared with many of the young students when I was here in Pakistan in this May. So ICC YAF is also one of the first forum for the young professionals with interest in dispute resolution. And be part of this global community, you will have more than 39,000 practitioners across the globe. And some of them, as a member, you can be a member of the ICC YAF, and later you will be nominated as ICC YAF representatives. And of course, if you have the chance to later participate in the West East in Hong Kong and also with Moot in Vienna next year, please also do join us during the Moot competitions. So for our region, so in Hong Kong, each year we will organize the ICC Cafe during the West East Moot competition, and we will invite all the participants for coffee during the breaks of your competitions. So I would say like from the P to the N, that will be the Pakistan that I want to present. And I just want to emphasize that I think this Pakistan national rounds of the Moot competition is definitely a good start for the Pakistani practitioners to be aware of the arbitration and ADR, and later to play your role on the global stage. So dear participants, I would say enjoy the gala tonight. And also, of course, you already enjoyed the Moot from already, but I think from tonight, I think you will be more closer to the world of the arbitration and ADR. And please stay connected with your teammates, your fellows, and looking forward to meet you all in this community of the arbitration mediation as well as dispute resolution. Thank you so much.
Thank you very much for your remarks, and now a very brief panel just for their remarks, and I would request them to keep it very brief because this panel and the closing remarks from Ms. Raquel are the only thing between us and dinner. So I would invite the panel led by Mr. Eric on the stage, please. Thank you.
Good evening. It may in fact be the case that we are short one on the panel, if not two, so this can be incredibly brief. By way of an even briefer background, my name is Eric Ives with the Commercial Law Development Program at the United States Department of Commerce, and for the last time, Honorable Tribunal, esteemed colleagues, I have but two submissions for you today. The first is congratulations on the National Moot. And the second submission is to introduce our esteemed panelist of one, Mr. Mia Samiuddin, partner at BNR and advocate of the Supreme Court of Pakistan. He has 15 years of commercial litigation and arbitration experience sitting and serving as advocate in the alphabet soup of panels, LCIA, SIAC, including a practice as arbitrator on the SIAC and Korean commercial arbitration panels. I will also say that he was a principal drafter of the proposed Pakistan Arbitration Law 2024. And in our brief panel, I have but one question to our esteemed panelist. How would the proposed arbitration law change the landscape of ADR in Pakistan?
Hello, can everyone hear me?
Oh.
Hello? All right, okay, so this is working. We have one more panelist, the Deputy Advocate General for KP. So thank you, Eric, for that question. For anyone who's read the new Arbitration Bill 2024, I'm sure you're all familiar that it is inspired with the UNCITRAL model law, which many countries now around the world have adopted. As Dr. Paracha said, this was earlier proposed in 2006, but there was a bill also inspired by the Indian Arbitration Act, but it didn't go through. This, by the Arbitration Law Review Committee, has been a fresh effort and really tailor-made to Pakistan's needs. Just quickly summing up what, in my view, how it will impact arbitration practice in Pakistan. The first is, obviously, it adopts a very pro-arbitration policy. Now, this affects two aspects common to arbitration practice. That is, enforcing an arbitration agreement. When one party in breach of the arbitration agreement files a suit in court, it is up to the court to enforce the arbitration agreement and stay those proceedings. The new arbitration bill creates a very high threshold for any party to challenge the arbitration agreement. It sets a prima facie standard for the courts to follow and allows the arbitral tribunal to carry out or make a first decision on the validity of the arbitration agreement. And in that way, it explicitly recognizes the competence principle. The second way in which the new bill is quite pro-arbitration is when it comes to challenging awards or challenging appointment of arbitrators. In that respect, it narrows down the grounds on which you can challenge a final award. Unlike the current Arbitration Act 1940, which allows an award to be challenged on various grounds that can fall under the rubric of misconduct of proceedings or otherwise the invalidity of the award. The new arbitration bill follows the New York Convention standards, which are set out in Article 5 and which provides very limited grounds for challenge. So those are the major, there's obviously much to it. The bill also encourages and sets the framework for developing a culture of institutional arbitration by giving powers to the high courts to set up an independent arbitration council, which can then subsequently promote and establish institutional arbitration. So those are the very quick, brief thoughts, so in order to not keep everyone away from dinner.
Thank you so much, Sami. And in fact, I misled you all. I have a third submission for the tribunal today. I'd like to introduce Mr. Shah Faisal Ilyas, Additional Advocate General of the KP region in Pakistan, and in fact, the youngest Supreme Court advocate in KP. He also served 2 terms as Secretary General of the Federal Bar, and we welcome you here today.
Thank you, Ji. Thank you. Ladies and gentlemen, distinguished guests and hosts, Assalamu alaikum. The KP government did a lot in this respect. We introduced Alternative Dispute Resolution Act 2020. In that act, we amend the 2017 Police Act Section 73, wherein we duly mentioned alternative dispute resolution for criminal as well as civil cases. And that resolution committee, dispute resolution committee, do exist in every police station of the province. There is, when 2020 Act came in field, in that act, we provide a specific mechanism to the litigants, and the concept of salice and salicine was introduced. As many of my brothers and sisters, you know that in our society we have a jarga system in KP, Patan setup. So in our culture, this alternative dispute system arises, and it is since immemorial time. Now we give it a codified shape in the shape of KP, Alternative Dispute Resolution Act. It consists of 30 sections. In this, the court or the deputy commissioner or any other tribunal can appoint a salis who will be one person, or salisin, who may be more than one person, who can give a verdict. And that verdict they give to the learned judge or that DC, which give that view, which they convert into a judgment, which become executable. And in this act, it is a fact that no appeal or revision lie against that very consent order. That is another aspect of the act. Furthermore, in this act, we can see a penal clauses too. If someone wastes the time of dispute resolution committee, then the committee have the power to even impose fine on them. Furthermore, this act also provide for 28 kind of resolutions to be settled by the committee. Furthermore, it empowers the court to first, in section 3, it is categorically says that in first instance, the court has to refer the matter to the arbitration committee, and thereafter, the same be if on 3 grounds it deems appropriate that it should not be referred to the arbitration committee or dispute resolution council, then that should be decided by the court. One of the reasons is that if the question of law or fact involve very serious in nature, so then in that case, the court has to decide it. Or the parties do not agree, so then the matter is to be decided by the court. In other ways, the matter in first instance, it should have to be decided by the alternative dispute resolution council. So I will further share this in black and white with the participant, this act, and I think the KP government did a lot in this respect. Although we don't have corporate sector in KP, but in the other such like situation, we did a lot. Thank you, Ji. Thank you.
Thank you so much, Faisal, and thank you so much, Sami, for being here. Just one quick, one-sentence question. What advice would you give to a young lawyer just starting out in their career?
Before attending these events, have a quick snack, otherwise you could feel really hungry. So.
Good advice. Faisal, any quick tip for a future practitioner?
In fact, we have a lot of potentiality in our field. So keep focus on your study, and I think you will be a successful lawyer.
Thank you both so much. And with that, I actually have the distinct pleasure of introducing the executive address of the evening, Raquel Martinez-Sloan. Ms. Sloan is an attorney advisor in my office, the Commercial Law Development Program, and also now a dear colleague and friend. Without further ado, I leave it to Ms. Sloan.
All right, good evening, everyone. I'll try to keep this brief. I know that dinner is waiting right outside, so this will be about 2 minutes. So good evening. Thank you, Dr. Puracha, for inviting me to make this really short executive address. As Eric mentioned, I'm an attorney advisor at the Commercial Law Development Program of the U.S. Department of Commerce. First, I'd like to congratulate all of you for participating in the Pakistan National Rounds. I understand this is the first year that this has taken place, so it's a huge achievement. Congratulations. The time for ADR in Pakistan is now, and you, the students, have a role to play in building and maintaining the ADR ecosystem for years to come. We are encouraged to see the movement for ADR gaining momentum in Pakistan, and we see that happening at all levels, at the judiciary, with local ADR institutions, with the practitioners, with academics, and with law students. We are also hopeful that legislative reforms, including those that were mentioned this evening, will move their way through, whether it's amendments to the Arbitration Act or the adoption of the Singapore Convention, and that strengthening the legal framework for ADR in Pakistan will make doing business in Pakistan easier. So with that, congratulations again, and I'm going to ask Dr. Puracha to come to the stage. So on behalf of the NUS team, we provide you with this gift as a token of our appreciation, both for participating as arbitrator in the final round, and also for hosting this wonderful event. Thank you so much for having us, and congratulations again to all of the student participants.
Thank you so much. Thank you. So thank you to all the guests in the room and online. With that, we will conclude this function, and we would like to invite all of you for dinner. Thank you.
Should we do that?
Yes.
I'm learning all the photo shoots.
That's the important part. Thank you. Thank you so much. So let's proceed to dinner.
Okay.
This is mine, I guess, or yours?
It was on there.
Okay. Thank you.
Okay.
Thank you so much.
Okay. I'm gonna go.